as scheduled. I called and spoke to whoever was working third, Senator Hychko. Yeah, can you send me down at like, 9:15? Thank you. You sent him down there or no? Alright.
That one also a little.
Two six domestic. Go. Hey, can you get a Stallings down there? I have back up here, please. The real comment. Yeah, anyway.
This is the Miss Maybrick one, so, this year, where's she at, visits?
Does she know she working? Huh? Does she know she gets?
No. And then I gave you that, I don't need it, I just know what it was.
I'll take a little bit.
Yeah, I'll leave it, it's like that, I think I put your home, all right, thank you.
Is there, I'll see when you get back. Where did this one go? Right here, bro. I will cut out what you want. There you go.
Morning, Mr. Stallings.
Morning.
Morning, we're here for your rep hearing. We're gonna get started, okay?
All right.
Good morning, I'm P.O. Meisinger, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Stallings Terrance, number 327846. Today is February 28th, 2025. This hearing is being conducted via video at the BOPP Central Office, New Haven Correctional Center. This is a public hearing and public access to the hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Terrance Stallings, 327846.
You have counsel here today. Please identify yourself.
Good morning. Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
How are you doing today?
Good, how are you?
This is a rev hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation or one or more conditions of your parole, I will reinstate your parole, release you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge the state your PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find that you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay. You have important rights today. You have right to have an attorney present. You have counsel here. You have right to receive the written notice that charges the violation. Did you receive the written notice?
Yes, I believe so.
You have a right to view the evidence against you, right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses or cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so we'll now review the charge the state your PO is bringing against you and the information underlying each charge. Charge 1 under the release section of Garner, your charging officer reported on 1/12/24. You left Renaissance East halfway house, drilling parole approved residence without permission or program completion approximately 21 minutes after arriving. At this time, your whereabouts in the community are unknown and you have failed to make contact with your parole officer or halfway house staff. The state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, parole conditions, B, parole violation report, C, notice of parole violation, D, notice of parole rights, E, agreement to actual custody order, F, Renaissance East Absconder incident report, G, CTDOC text log between Stallings and McLean, H, CTDOC DNA history report, transcribed phone calls. Did you receive notice of parole violation report, and those other documents I marked, did you review them?
Yes, ma'am.
Okay, and counsel has filed the following exhibit, pre-marked for identification purposes, Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we do not.
Okay, we have no witnesses. I am going to put on the record, though, there is an addendum and it reported on 2/6/24. The BOPP did issue an absconder warrant for the offender. So now is the defense's opportunity if you'd like to speak regarding the charges.
As a result of the warrant being issued, and the standard date being 1/12/24, I have no comment as to the bond standard.
So what I'm going to do next, I'm going to announce my findings. So on that charge one, I do find you violated the condition release just an absconder based on a warrant being issued by the BOPP and evidence that was provided in support of the charge, which is exhibits A, B, and F. So that includes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to.
Yes, the PO recommended a 6-month sanction. I would ask for a shorter sanction than that. My client is a single 36-year-old male. His family has reportedly all passed away. He was raised in the foster care and prison system beginning as early as age 9. He was placed in the past at the Renaissance Halfway House program. While he was not at the halfway house, he was employed in December of 2024 at a grocery store. He has a history of mental health diagnoses and treatment, including medication management. In the past, he's been shot, which has resulted in also physical issues that he's recovering from. He is reportedly medication compliant from incarceration. He's on the waiting list for programming, which he voluntarily has pursued. Upon reinstatement, he does not wish to be placed in a city. Mr. Stallings, if you're placed in a halfway house in Connecticut, I would suggest Norwich. Almost all of them are in city areas, and Norwich is the smallest community. So would you accept the placement in the Norwich area?
Yeah, and so I can do the interstate compact.
No, you can't do interstate compact. You're absconded. So you have to be placed in a halfway house in Connecticut for a certain period of time.
Yes,
Once
I'm
you show
aware of that.
compliance, you can apply for if you'd like to transfer out of state.
Yes, please.
He wishes to obtain his GED. He wishes to enroll in tractor trailer training school and get his CDL license. He's interested in landscaping until he obtains that CDL license, and he wishes to pursue a driving position. He's amenable to a medication management and all treatment, and he will establish primary care services in the community for his medical needs. Once again, my client is 36 years of age. He virtually had no support growing up. He left the halfway house because of concerns for his safety. He's very concerned for his safety. There have been threats to his life continuously in the past. There are no graduated interventions and sanctions, obviously, in that 21-minute period. However, I don't believe a 6-month sanction is necessary or appropriate here. Whatever can be structured for his utmost safety in the community is what we would recommend. Obviously, you can work with your parole officer, sir, if you choose to try to get some sort of work with the local police, do something like that to try to keep yourself safe. Okay, do you have anything to add?
No, sir.
Okay. Thank you. Thank you for your time and consideration.
Thank you. So I have reviewed the case. I've listened to testimony, reviewed the evidence provided by the state. I do see you were on absconder status. You were absconded for approximately a year before turning yourself into custody. You were in the community for only 21 minutes before you absconded from supervision back in January of 24. You do have a history of absconding as well. It is noted that on discretionary parole, you absconded in December of 21. You don't have any prior violations on this period of parole supervision, as was stated, or misconducts. You were only there for 21 minutes. You are on special parole for 10 years. So it is very important that if you abscond, you're never going to complete parole. So you need to make sure you're talking to people like your parole officer if you're having problems or you have concerns, so that this doesn't happen again.
Yes, ma'am.
So taking everything into consideration that was stated as well as evidence, I'm going to recommend that parole be revoked, be re-paroled for June 10th of 2025. It's about a 5-month period of confinement as a sanction. I recommend the following parole conditions: a halfway house instead, preferably Norwich, no contact with your victim, KB, a general no contact with Desmond Griffa and Alante McLean without PO's permission, and a mental health evaluation and treatment as deemed necessary. My findings are going to the parole board. That will be on March 13th. So the board is going to review my recommendation. So the board can lessen the sanction, they can keep it the same, or they can make it longer. The board does have ability to revoke special parole. So just be aware of that, and hopefully that will be some motivating factor to you to do right out there and not come back. As well as you said, you'd like to go out of state eventually.
Yes, ma'am.
So just do it the right way and comply with parole and do well, and then they can work with you to get you transferred to where you want to go. Okay?
Yes, ma'am.
Do you have any questions? Do you understand?
Yes, I understand.
So give me a call on March 14th, the day
All right.
after the hearing, and I'll let you know what the final decision was, okay, sir?
All right.
You're going to get it in writing too. About a week after March 13th in the mail, you get something from the parole board, and it'll tell you what the board's decision is and what your conditions are.
All right.
Okay?
Thank you.
Have a good day, Mr. Stallings.
Good luck,
All
sir.
right.
You're all
Enjoy your
set.
weekend.
Good morning.
Morning, how are you?
Good, how are you?
Good.
Is P.O. Montoya there too as well? Perfect.
Good morning, everyone.
Good
Morning.
Like your shirt.
They make fun of me a lot because it's purple.
I like the purple.
Yeah.
His video conference, it's and he told me a little bit. Just the Garner. Then my guy might come in. Who's on a deviate? You gave him a plan, around the way. I don't know how they hold, but it's up to them.
I don't know.
Good morning, sir.
I'm good. I'm gonna deny this whole thing.
Well, we'll sit down for a second. 'Cause I have to talk.
Good morning,
to you, so-
Paul. Good morning, Paul. Why don't you have a seat? We're going to get started with your hearing.
If he refuses to show, we're just gonna continue without him.
What did he, I'm not even sure what he said.
He says he's not doing any of this.
Oh,
So I'm taking that as he's waiving participation. So we'll just continue without him if he does refuse.
okay. I can't really see. Did he leave the room?
Yeah, he's gone. I'm just waiting to see if the officer comes back in. If we
Yeah.
can get him back
Yep.
in or not.
Okay. Okay. Thank you.
For Saunders? Okay, thank you. So Mr. Saunders is on his way.
So Mr. Hychko left.
Yeah, he says he doesn't want to be part of it.
He doesn't, so, I get he's refusing to participate. So what I'm gonna do is I'm gonna continue his hearing right now with, the officer as well as his attorney. So I'm gonna live stream this and do his hearing without him.
Okay. So
Um,
how long do you think for your other client, for Saunders? Just so we're not interrupting you guys.
how long until I see him?
Yeah.
Maybe 10 minutes?
Okay, yeah, no
Max?
worries. I'll
Yeah.
have him just wait out here then.
Perfect. Thank
Alright.
you.
Yeah.
All right, so I'm gonna go on the record, so we'll continue without him as he declined to be here. So I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles. This is a preliminary hearing, so Hychko Paul, number 377114. Today is February 28, 2025. This hearing is being conducted via video at the POPP Central Office, New Haven Correctional Center. This is a public hearing. Public access to the hearing is available via video live stream. Mr. Hychko has refused to participate in his hearing, and therefore we are continuing the hearing with his attorney as well as Parole Officer Montoya. So this is for, as I said, Paul Hychko, 377114. So can the Parole Officer present please identify yourself?
Good morning. My name is Catherine Montoya. I'm a parole officer at Waterbury District Office.
Okay, and then we have counsel present today.
Yes, thank you. Attorney Sonia Jones, Public Defender's Office, Parole Revocation Unit. Thank you.
This is a preliminary hearing, which is the purpose under Connecticut law to determine if there's probable cause to believe offender committed an act of violated conditions of parole, determine if the act is sufficiently serious to warrant revocation of your parole, and determine if you should be held in prison pending further proceedings. The state, not you, has responsibility to show there's probable cause to believe you violated one or more conditions of your parole. If I do not find probable cause, reinstate your parole, which is releasing and place you back on parole supervision. If I find probable cause and determine the act is sufficiently serious to warrant revocation, you may be held in prison pending further proceedings. You should know a preliminary hearing is an adversarial proceeding, and anything you say in this hearing can be used against you. This hearing is being recorded. Before I continue though, Attorney Jones, do you want to continue with the hearing or would you want to waive the prelim?
I mean, I do have some comments. I do have some comments that I'd like to make on his behalf. I obviously wasn't anticipating that he was going to walk out of the hearing. So I guess I would still like to make those comments. I mean, I understand they probably won't make a difference, but in light of him leaving the room, but yes, I think I would still like to place those comments on the record.
Okay. So this is procedure. I'm going to read the rights. Then we're going to review the parole violation charge the state parole officer is bringing against him. I will review and identify exhibits filed for the record. The state will have an opportunity to just issue probable cause associated with the allegations. After the state is finished, counsel will have the same opportunity. At the conclusion of the hearing, I'll inform you my findings, which are based on the available evidence. Those important rights, the offender has the right to have an attorney and the attorney is present. Did he receive the written notice to charge the violation?
Yes.
Okay, you have a right, he has a right to review it, to submit evidence in support of his case. At this hearing, he has the right to call and examine voluntary witnesses. So we're now going to review the charge that the parole officer is bringing against him and the underlying information. So P.O. Montoya, you please read the charges.
Good morning. Charge 1, program participation. On 12/31/2024, you were directed by this parole officer to complete a substance abuse evaluation and treatment as deemed necessary. On 1/9/2025, you completed an intake at MacDougall Foundation. MacDougall Foundation recommended you to attend intensive outpatient group 3 times per week, beginning on 1/13/2025. You left intensive outpatient group early on the following dates: 1/16/2025, 1/23/2025, 1/27/2025, 1/29/2025, 1/30/2025, 2/3/2025, and 2/5/2025. You failed to attend intensive outpatient groups on 2/6/2025. You were negatively discharged from MacDougall Foundation on 2/10/2025. Second charge is drugs. On 1/8, you submitted a toxicology screening at MacDougall Foundation and tested positive for fentanyl use. On 1/13/2025, you submitted a toxicology screening at MacDougall Foundation and tested positive for fentanyl use. On 1/22, you submitted a toxicology screening at MacDougall Foundation and tested positive for fentanyl use. On 2/4/2025, you submitted a toxicology screening at Waterbury Parole and tested positive for fentanyl use. On 2/8/2025, this officer received a call from Waterbury Police Department who reported that you overdosed were given 4 doses of Narcan and were sent to the hospital, Waterbury Hospital, for treatment. I also want to add, bring to record that on 2/20/2025, they were doing a cell search and they found Class A contraband, marijuana in Hychko's possession. Hychko was issued a disciplinary report by New Haven DR investigators on 2/20/2025, and he pled guilty on 2/21/2025. I just wanted to bring this to record for the consideration at the revocation hearing, if there's any.
Thank you. And the state is filed following exhibits. What?
Can I just inquire, was she attempting to add that as part of the charge or just indicating that that's like an addendum?
That's for record.
Just an addendum, I believe.
Okay, thank you,
Yes,
thank you.
Yeah. Yeah.
Okay, thank you.
And the state is filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remand of custody order, B, parole condition, C, parole violation report, D, notice of parole violation, E, GPS agreement form, F, McCall Foundation subuse eval and recommendations, G, email from McCall Foundation to 625, H, McCall Foundation recommendation for higher level care dated to 625, I, Quest Diagnostic Toxicology Report dated 1/8/25 positive for fentanyl use, J, Quest Diagnostics Toxicology Report dated 1/13/25 positive for fentanyl use, K, Quest Diagnostic Toxicology Report dated 1/22/25 positive for fentanyl use, L, Premier Biotech Lab Report dated 2/4/26 positive fentanyl use, M, McCall Foundation notice of partial day intensive outpatient groups left early on 1/16/25, 1/23, 1/27, 1/29, 1/30, 2/3, 2/5/25, failed to attend intensive outpatient group on 2/6/25. N, timeout program referral date 11/1/24. O, timeout program compliance discharge report successful completion. P, revocation hearing summary dated 1/17/24. Q, timeout program referral dated 4/8. R, timeout compliance discharge report unsuccessful completion. S, revocation hearing summary 6/26/23. T, Waterbury Police Report ending in 13198. U, McCall Foundation email reporting that Hychko was discharged from the program dated 2/10/25. V, Waterbury Police Report ending in 14047. W, timeout program referral date 2/10/25. X, email from top declining top placement. And Y is timeout compliance discharge report and eligible for top program. So did the offender receive the information and review it with you guys at the office?
Yes.
Okay. We have no witnesses. Do you need to continue the hearing to obtain any additional evidence?
No.
Okay. So I am just going to swear in Theo Montoya at this time so you can speak today. So can you please raise your right hand? You solemnly swear or solemnly affirm as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
They do.
Okay, would you like to say anything at this time?
Good morning, everyone. So I have had Paul for a number of years. He was violated on 11/15/2023. He was revoked. He was re-released back to me on July 16, 2024. Between July 16 and September 10, 2024, he was doing okay, attending treatment. He started using. I attempted to work with him. On 9/10/2024, due to his drug use, mom withdrew the sponsorship. She no longer wanted him in the house. At this point, he was placed at the halfway house. At the halfway house, he did very poorly. He continued drug use, and he was caught with a hypodermic needle. So P.O. Jackson at the time placed him at the TAP program on 10/25/2024. He completed TAP on December 31st, 2024. He was directed to complete the substance abuse evaluation on 1/8/2025. He completed that with no problem. Between January 8th and 2/4, Hychko appeared to be in compliance. He was on GPS and he was compliant, coming home every day, charging his unit. He appeared to have been going to treatment. He was coming to see me. On 2/4, he reported to see me and he tested positive for fentanyl for the first time with me. He did not use. He's like, no, I didn't use. I don't know why he's positive. I was like, okay, let's send it to the lab. Let's figure out what's going on. Come back and see me on the 11th. Because he was on weekly, I had him on intensive supervision. This happened on 2/4. On 2/5, February 5th, mom calls. And she's very concerned because she's like, he's using a lot. I'm concerned for his safety. So I'm conferring with mom. At this point, Paul walks into the room, realizes that mom is on the phone with me, becomes very aggressive on the phone, which is, he's never done that with me before. He's, throughout the years that I supervised him, the multiple times that I brought him into custody, that I brought him to a halfway house. Was he upset? Yes. But was he aggressive towards me or disrespectful? No, he was not. But on this occasion, on February 5th, he was very aggressive, and he started screaming, cursing me out. And he, reported, come and get me, and I will squish you like a bug. And, it's the first time he ever expressed that he was going to do violence against me. He's never done that before. Mom became agitated. He was very agitated. And at this point, I'm still waiting. All I wanted him to do is report to see me at the Waterbury Parole office, to pee in a cup, so I know what he was using and if he was still dirty for fentanyl. He refused to come. And since I already had a schedule reporting with him on February 11, that's fine. We're just going to drop it. I don't want any issues. It's fine. I'm going to see you on February 11. Please just report to see me on February 11. So this happened on the 5th. At the same time, overnight into the 6th, I get a call from Waterbury PD saying that the family had called them and initiated a medical call and a police call because they believed that Hychko might have overdose. This is, the morning of Thursday, February 6th. By the time police got there, he was alert. He was talking. So the police left with no arrest or anything. He wasn't sent to the hospital. On the 6th, I talked to mom again with the supervisor, and mom is again saying, I want him out of the house. I don't want him here. And at this point, Waterbury Parole, we didn't have halfway houses. They're filling every single bed every day. So we have no available beds for emergency placements. It's very rare that we get one. And at the moment with mom was saying, get him out of the house, I didn't have any available bed. But I said, mom, we'll figure it out on Tuesday. Bring him to see me on Tuesday, day 11, and I'm going to figure out a plan. I said, if you don't want him in the house, he's going to EOS in 3 months. Will you be open to getting him his own room, like rent a room somewhere? Because I was still willing to supervise him out in the community, trying to do progressive discipline, see if we could, make it work with him. Mom said no. So I gave mom like a safety plan, like, hey, listen, between now and the 11, if you feel unsafe, call 911. If you feel there's a medical emergency, just get an ambulance and, we'll figure it out. So this happened on the 6th. At the same time, I picked up the phone, called his program provider, and I'm told for the first time on February 6th that he's been using a Renato and that he's missing all these programs. So up to this point, I had no idea that this was happening. It was not informed to me by the treatment provider. And at the same time, they also recommend higher level of care. So I secured higher level of care. So I figured, okay, I'm going to put him at the top program on the 11th because I still want to work with him because, again, Paul is complying in almost every aspect of his supervision except drug use. He just won't stop using drugs. So at this point, I'm still willing to work with him, progressive discipline, even if he's short because he's going to EOS in 3 months. So that's the plan. We're going to bring him into custody on the 11th to the top program. During the weekend on the 8th, Saturday the 8th, I get a call from Waterbury PD that Hychko had overdosed. He basically almost died. Mom found him purple, foaming at the mouth. He had to be Narcan 4 times. He woke up. He was acting very violent, saying, crazy things, that he wants to kill people and he wanted to kill himself. So at this moment, the police call an ambulance and commit him to Waterbury Hospital. So the plan was for me to get him at the hospital then on Monday morning, the 10th. However, Waterbury staff, the hospital, mental health felt there that he was stable, and they released him on Sunday, the 9th at 9:45 in the morning. I confirmed with my supervisor, and it was decided that we were going to bring Paul into custody on the 10th. He was told to report, and he came to see me, and he reported, and I was able to take him into custody with no, without any issues, no violence or anything. But I will say in regards to Paul that I think it's a miracle that he's still alive, that he's still here with us, considering the amount of drugs that he's consumed and the amount of times he's overdosed. I give credit to the fact that mom is in the medical field and she has been able to basically bring him back a number of times. But, you know, I still attempted to work with him, trying to put him in the top program, but due to his time frame, he doesn't meet the criteria for top. So then the only thing I can do is just request a full revocation, and just basically because I just want him to just finish alive with us at this point. Thank you.
Thank you. We'll turn over to council.
Yes, thank you. Just briefly, in regards to charge 1 under program participation, I would simply report that my client, as the charge indicates, that he left early from these groups on several occasions, and he did tell me that he would leave about 5 minutes early along with other participants, as the medical cab would arrive at that time, and that he needed to get into the cab in order to have transportation back. That at no point did the program have any problem with that until he was violated, and they said that he left early all of those times. He didn't dispute that. He simply indicated that it was by 5 minutes, that other individuals in the program were also getting into that medical cab and leaving at the same time. And then no comment as to charge 2.
Thank you.
I will refute that medical cabs are scheduled after IOP is over. IOP had asked him multiple times not to leave early. Paul is huge and very intimidating, and he will just get up and leave. And who is gonna tell him to stop? So no, I don't believe that. The program was very clear that he left more than 5 minutes early on multiple occasions.
Okay. All right, so what I'm gonna do next is I'm going to announce my findings. So regarding the charge 1, I do make a finding of probable cause on program participation based on evidence presented in support of the violation, which is exhibits B, F, G, M, and U. And on charge 2, I do make a finding of probable cause drugs based on evidence presented, which is exhibits B, G, I, J, K, L, and V. And I do find the acts are serious enough to warrant revocation. I determine the offender should be detained while he waits for a revocation hearing. So I know his EOS date is May 1st.
Right. So it's just some of the comments that I wanted to make were simply that listed in the graduated interventions and sanctions section for this period of supervision, none of the things that are listed there pertain to this period of supervision. And I just wanted to point that out. So in regards to this period of supervision, there are no graduated interventions and sanctions listed. He began this period of supervision on December 31st of 24 after he successfully completed the top program. So all of those that are listed are for a previous violation. And then I would just point out that on 2/6, when his parole officer does indicate that she was able to obtain a recommendation for a high level of care from the treatment provider, but I'm not certain why that higher level of care had to be the top program and why it wasn't an inpatient treatment program. And though I understand that those beds are hard to come by, I don't see any evidence of what effort was taken to place him into an inpatient treatment program. So certainly, once we learned that he was not eligible for the top program based on his EOS date, I'm not sure why putting him into a treatment program in the community that was inpatient wasn't considered, or what efforts in fact were made to do that. On 2/8, it indicates that he overdosed at the hospital and he's discharged, and he's directed to report to parole on 2/10, which he does, and he's taken into custody. So at no point is he trying to evade. It seems as though he wanted treatment. So again, knowing that he was not eligible for top based on the time remaining on his sentence, that he's EOSing on 5/1/21, he certainly could have benefited from treatment in the community. And so that would have been our position, is that we would oppose further incarceration and ask that he be placed in a inpatient treatment program within the community. I know that several of our parolees are typically placed in the App Foundation. I don't know if that was an option. It doesn't appear to have been explored here. I don't see any evidence that it was. And those were my comments that I wanted to make, but I respect the findings. Thank you.
I would like to respond.
Go ahead.
Okay, first of all, thank you for your comments, Attorney Jones. First and foremost, when I placed him at the top program, I did not know he did not have enough time. I thought I was going to have enough time for him to come back out. Number two, it is a matter of life and death when it comes to Paul Hychko. He is, mom sent me pictures of him stumbling around the house, knocking things off the wall, falling over. His arms are full of track marks. And while I wait for a bed, while I arrange for an intake, while the program decides whether to take him or not, Paul can die. I just don't understand if people understand that he could die. It's an emergency. Most times I do pursue app placements or programs in the community. When it comes to Paul, it's a matter of life and death. And I do not want that on my conscience, on my hands, and I don't want the department to have any liability. Number two, he has a lifetime ban at APT due to his behavior there. So APT Foundation was not an option for me. Thank you.
Thank you. And I will put on the record just as well that the offender has been on parole since February 28th of 2023 for discretionary parole and does have a prior top placement and 2 prior technical violations, as well as received 5 misconduct. So I did take that into consideration as well into this case. So the findings still stand. So he will have a rev hearing because he does need to have one by April 11th. So he is going to have a hearing, and we'll determine what happens then as well.
I will make
Thank you,
sure to
guys.
complete an addendum and add the DR.
Yes, I'll put you down as attending for the rev as well.
Yes, please. Thank you.
Okay. All right.
All right,
Well,
thank you.
guys.
Thank you, Pia Montoya.
Thank you, Jones.
Have a good day.
Oh, baby.
You ready for the next one?
Yes, please.
All right.
So.
Morning, Mr. Saunders.
Morning.
So I know you had asked for a legal counsel and they tried to schedule your call. So they had to reschedule it, I guess, until March 3rd. So do you want to move forward today without counsel, or do you want to wait until you speak with counsel?
I'll wait to speak to him.
Okay. You also have the ability, if you want to waive the preliminary hearing, that's also an option that you do have, as you do have pending charges. So that is an option as well. So it's your choice what you would like to do.
Yeah, I'll wait for counsel.
Okay, so I'm just going to go on the record and then I'll continue your case. My next hearing date that I have is March 11th. So that would be your new hearing date for your prelim. Okay. So I'm just going to go on the record. On the record for Saunders, Jesquan, number 397044. Today is February 28th, 2025. So you are requesting the attorney representation. So I will accept your request to obtain legal counsel. So I'm going to continue your case to March 11th, which is my next hearing date. And then you will speak with legal on March 3rd.
Okay.
Okay, and then you could talk to them and decide what you want to do, okay?
Okay.
Okay, so you are all set for today, sir.
Thank you.
Good luck.
Thank you.
Good morning.
Okay.
Good morning.
Is this for Burgos?
Yes, it is.
All right, I'll go get him right now.
Thank you. Good morning, sir.
Good morning, how you doing?
Good. We're here today for your revocation hearing. So I have your attorney here, so we're going to get started with that, okay?
Yes, ma'am.
Good morning. I am P.O. Meister, a hearing examiner for the Board of Paroles and Paroles. It's a revocation hearing concerning Burgos 1, number 244208. Today is February 28th, 2025. This hearing is being conducted via video at the BOPP Central Office, Hartford Correctional Center. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Josue Burgos, 244208.
Sorry, I said Juan before. We'll correct that. Okay. And you have counsel here today. Please identify yourself.
Yes, good morning. Attorney Rob Famiglietti of the Parole Revocation Unit of the Public Defender's Office. How are you, sir?
I'm good, how you doing?
Good morning.
So this is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing you and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction. My recommendation will be given to a panel for final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. This is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PO is rained against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present relevant testimony. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights today. You have right to have an attorney present. You have counsel here. You have right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have the right to review the evidence against you before this hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes, ma'am.
All right, so now review the charge. The state your PO is bringing against you and the information underlying each charge. Charge 1, release direction drug testing. Your charging officer reported on 12/6/24. You were asked to render urinalysis for toxicology testing. On 12/9/24, the results of the urinalysis returned from Redwood Toxicology Lab with the results specimen is abnormally dilute. Charge 2, unavailable drugs. Your charging officer reported on around 10/1/24, use cocaine. On around 10/22/24, use cocaine. On around 12/6/24, use cocaine. And the state has filed the following exhibits and are pre-marked for identification purposes as Exhibit A, notice of parole violation, B, notice of parole rights, C, agreement to actual custody order, D, PCS signed conditions, E, halfway house agreement, F, PCS signed conditions, G, halfway house agreement, H, offender misconducts, I, voluntary drug admission, J, Quest Diagnostic Toxicology Lab Report, K, offender misconducts, L, Quest Diagnostic Toxicology Lab Report, M, PCS signed conditions, N, halfway house agreement, O, offender misconducts, P, signed halfway house disciplinary report, Q, voluntary drug admission, R, Redwood Toxicology Lab Report, and S is parole violation report. So did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes.
And counsel has filed the following exhibit pre-marked for identification purposes as defense exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay. We don't have any witnesses, so is now defense's opportunity. If you'd like to speak to any of the evidence submitted at this time?
Yes, no comment as to charge 2, but however, to charge 1, the preponderance standard for drug testing, specimen is abnormally dilute. That could have been for any number of reasons. There's no allegations that he in any way tampered with the urine. He's not charged with tampering with the urine. I would argue that there could have been something in his system that wasn't drugs, or he could have had a lot of anything could have caused it to be abnormally dilute. I don't believe it violates the elements or meets the elements of drug testing. He did cooperate. He did give a sample. It was tested. Just the results came out a way that we can't assume that something negative happened as a result of that. Thank you.
Right, so what I'm gonna do next is I'm gonna announce my findings. So on charge 1, I do find you violated condition drug testing based on evidence that was provided, DPR. And in that includes the admission that you said that the urine sample collected on 12/6/24 was water that you admitted to staff. On charge 2, I do find you violated condition obey a law's drugs based on evidence provided for the charge. Exhibits D, H, I, J, K, O, P, and Q. That includes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
Yes, we believe this should have been a top. He completed the app foundation, 30 days at the app foundation. He successfully completed that. He did complete the app foundation. He was released with not enough Suboxone. That I believe would explain the December test. He has used TOP in the past, but he was successful. He needs treatment. He does not need additional jail. He's been held now since December 12th of 24. It's been 52 days, business days since his remand. He was on parole for approximately 5 months. I believe this is his first violation since that TOP. He obviously suffers from drug issues. That is not going to be solved by further incarcerating him. He's 48 years of age. He has 5 siblings. 3 weeks after his release, following a lengthy bid, his mother passed away, so that was a significant stressor for him. He has 4 children, ages 28, 25, and a 17-year-old who's graduating high school this summer. He does not wish to miss that at all. We'd like him to be released as soon as possible. He also has a 13-year-old. He had a job for 2 months at Dunkin' Donuts in London, and then he was hired for a full-time position at Safeside Chimney and Duck Cleaning, where he can return, and we confirm that. He has successfully completed outpatient treatment at Wheeler Clinic, IOP at Rushford, and then the app foundation that I referred to from October 23rd to November 27th. As I mentioned, that positive test from the 6th of December, shortly after his release, he was not given enough Suboxone, and so he relapsed. He's medication compliant, which he finds to be helpful. Upon supervision, released to supervision, he was to be sponsored by his daughter in New Britain, and he can return, as I stated, we spoke to the hiring manager at Safeside Chimney. He can return to that job, and he's amenable to all treatment. Once again, we believe he needs treatment. The parole officer recommended jail up to the board. However, treatment is appropriate. Thank you for your time and consideration.
Thank you. So I did review all of the evidence submitted by the state. I've listened to testimony. Open the record. Defendant does have 1 prior top placement, as well as received 3 misconducts on this period of supervision, which was about 5 months in the community. I do believe that defender does need treatment in the community, and would benefit from that for more than he would from sitting in jail any further. So I am going to recommend that parole be revoked to be reparoled from March 13th, 2025. It's about a 3-month period of confinement as a sanction. That's my next available board review date that I have to present your case to the parole board. I recommend the following parole conditions: no conflict with your co-defendants, Angel Carskilo, Louis Quintero, no contact with your victim, Family Dollar, 453 Franklin Ave, Hartford, Connecticut, Behavior Management Program for Domestic Violence, general no contact with Jessica Gonzalez without PO's permission. My findings, as I said, are going to go to the board on that day of March 13th. So if the board agrees with me, you would be released that day. They can disagree with me though, and then you'd have a supplemental hearing. Just that's a possibility, but not a strong possibility. Do you have any questions?
How will I know like when that they agreed or didn't agree?
Because you're gonna leave that day.
Oh, I'm
They'll
leaving
come
that
get
day?
you. If they agree with me, you're off. They're gonna come get you.
So
All
on
right.
March 13th, if
Yes.
if you don't leave that day,
Yes.
call me on March 14th and I'll explain what happened, okay?
All right.
But I hope not to hear from you on the 14th.
All right.
okay?
All right. Me
All right.
also. Thank you.
Just make sure
Thank
you engage in treatment as soon as you get out. You know,
Definitely,
get involved in
definitely.
inpatient through, if you like Wheeler, go to Wheeler. And
100%.
get involved so this doesn't happen again, okay?
Definitely will. Appreciate you.
Okay.
Good luck.
Sir.
Thank you.
Post.
No, you can keep it over. Is Dean downstairs?
She is downstairs.
Yeah, so she'll be up. Thank you.
24, jeez, fuck I don't. Still doing this shit?
Morning.
He doing his way down.
Okay.
Saw him 15 minutes ago. I don't know what's taking him so long.
Okay. Thank you.
Oh, what was we 9 p.m. Regular?
Hello, so Rosegreen, he's actually an IPM right now, so he's in inpatient medical, which they bring him to a separate part of the facility. I just spoke with, I believe it was Tracy who just called me, and she was asking me if he was coming down, but he's no longer in mental health 4 block. He's now in mental health 5, so he would be going into another location.
Okay. Is he going to another location? You mean another camera?
Correct. So it's basically versus the visiting room is more of a secure location since he's a mental health level 5. Yeah. So right now, I think, yeah, they're
Sorry,
in the
do you
process.
happen to know the name of that device, that computer?
That I don't know. I don't get too far into the technical things or that sort as far as computers, just locations. But right now they're in the process of figuring out, since he had that move where he getting him down there and getting him signed off.
Is he just changed recently to a 5?
Correct. This was probably about 2-3 days ago.
So the thing is, I don't think we're gonna be able to connect if he's in a different room because we're set up for these devices.
Okay.
So, I mean, if he's been stable at some points, then, I mean, if it's kind of a medication thing, I can continue his case to my next hearing date. If it seems like something that's probably gonna have to happen.
Yeah, again, I'm not sure, where he is. I'll be with a mental health professional. So basically, right now we have our higher ups contacting them and seeing how they want to go about getting it done.
IPM, right?
IPM, yeah.
He's coming right now.
It's coming right now? All right, so I guess he's gonna be escorted down here then.
Okay.
Okay.
Thank you so much.
You're welcome.
Yeah, he changed to a mental health 5 yesterday.
Thank you.
You're welcome.
I know, but see what's up. Until we figure it out.
Right now.
Hi, is he, like, okay enough? I mean, can he understand things?
Should be able to, what's up? She wants to know, is he okay enough to?
Is he gonna understand? Hi.
How you doing?
Good.
What was that? I'm sorry.
I said, is he able to understand everything?
Yeah, you should be, yeah.
You're good,
I believe so.
Rosegreen? Do you want to continue your hearing today, or do you want me to push you out 2 weeks?
No, you push me out in 2 weeks, yeah.
You want a hearing today?
Yes, today, please.
Okay.
Just have a seat there, all right?
Okay.
If they need anything, we'll switch out this customer. If they need us to, okay? We'll be right here. I'll sign.
Thank you, guys. All right,
No problem.
Mr. Rosegreen, all right, so we're gonna start your revocation hearing then, okay?
Okay.
And P.O. Davis, you're here?
Yes, I'm here. Good morning.
Okay, so we're gonna get started. So good morning, I am P.O. Meister, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Rosegreen Lamont, number 279798. Today is February 28th, 2025. This hearing is being conducted via video at the BOPP Central Office in Garner Correctional Institution. This is a public hearing. Public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record, sir?
Rosegreen. I'm not Lamont Rosegreen. 279798.
Thank you. And we have a parole officer present. Can you please identify yourself?
Parole Officer Patrick Davis. I work out of the Hartford Parole District Office.
And we have counsel here today. Please identify yourself.
Yes, Hannah Dean on behalf of Mr. Rosegreen. Good morning, sir.
Good morning.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has the responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find you violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, state your PO is bringing against you. I will review and identify exhibits filed for the record. The state will have an opportunity to present a relevant testimony. After the state is finished, counsel will have the same opportunity. After considering all the evidence presented, I'll announce my findings. If I find you violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure, Rosegreen?
No.
Okay. Your important rights today, the right to have an attorney present. You have counsel here. You have a right to receive the written notice that charges the violation. Did you receive the written notice?
A while back, but
Yes.
I wasn't able. Okay.
Yep. You have a right to view the evidence against you. You have a right to submit evidence for to your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to go forward?
Yes.
Okay, so now review the charge, state your PO is bringing against you, and the information underlying each charge. So PO Davis, if you can please read, that would be charge 1, charge 2, and charge 5. Charge 3 and 4 and 6 are not taken into consideration as no findings were made at the time of the prelim.
Sure. Charge number 1, GPS. On 8/6/2024, you failed to charge your GPS, resulting in a shutdown of the unit from 12:38 a.m. to 7:14 a.m. And again that same day from 10:26 p.m. to 8:27 a.m. 8/9/2024. This is a violation of your signed GPS agreement. On 10/19/2024, you failed to charge your GPS, resulting in a shutdown of the unit from 8:02 p.m. to 12 a.m. 10/20/2024. This is a violation of your signed GPS agreement. On 11/20/2024, you failed to charge your GPS, resulting in a shutdown of the unit from 1:08 a.m. to 8:32 p.m. 11/21/2024. This is a violation of your signed GPS agreement. On 12/12/2024, you removed your GPS unit without permission from this officer. This is a violation of your signed GPS agreement. Charge number 2, curfew. On 5/1/2024, you were instructed of your GPS curfew of 9 p.m. to 6 a.m. At no time were you provided with any other curfew or given permission to be out past your curfew. On 10/26/2024, you did not return home until 9:12 p.m. This is a violation of your signed GPS agreement. On 10/28/2024, you did not return home until 9:15 p.m. This is a violation of your signed GPS agreement. Charge number 5, obedience to the law. On 12/11/2024, at approximately 4 p.m., you arrived at the location of 300 Sheldon Street, Hartford, Connecticut, 06106 HDO. You were acting erratically. Your behavior suggested you were having either a drug-induced or mental health incident. Parole officers responded to the scene and requested HPD and EMS due to your behavior. You were observed blocking traffic in the intersection with a parked vehicle, running out of the vehicle and attempting to run onto the adjacent highway, I-91 exit ramp, not listening to verbal commands or instructions, speaking in a way not to make any sense, crawling and exposing yourself and making lewd gestures to multiple responding staff members and those in passing cars that were unable to leave the scene due to your blocking of the road. It was determined that you may be a danger to yourself and society. EMS transported you to Hartford Hospital without incident. Once you were there, you were uncooperative with hospital staff and were discharged due to your non-compliance. Your behavior is a violation of breach of peace, Connecticut General Statute, Section 53A-181, and public indecency, Connecticut General Statute, Section 53A-186, Exhibit M. Want to make sure I'm reading the right one here. On 12/12/2024, upon arrival to Hartford District Office, you were observed via video camera footage opening the door to the office. In the entranceway, an employee of Hartford District Office Maintenance and Custodial was performing his daily job duties. This employee is contracted through Easter Seals, which is a company that employs disabled and mentally compromised individuals. You were observed physically putting your hands on this employee and pushing him out of the doorway. You obviously frightened said employee because he immediately put his hands up and wanted no part in getting in your way. After pushing said employee outside, you were seen entering the elevator. You then exited the elevator and kicked the wooden door behind the entrance and proceeded upstairs to the lobby. Based on your behavior, you are in violation of breach of peace, Connecticut General Statute, Section 53A-61A, assault in the third degree of an elderly, blind, disabled, mentally retarded, or pregnant person. On 12/12/24, you reported to the Hartford District Office. Upon arrival, you were observed in the elevator of the Hartford District Office acting strange and attempting to take your shirt off. Once in the lobby of the Hartford District Office, you began your non-compliant behavior by making other offenders feel extremely uncomfortable for their safety. You were forcibly moving lobby chairs around, raising your voice and screaming. You were then observed ripping your GPS monitor off your ankle and threw it in the lobby that was filled with other offenders. Based on your behavior, medical services were called, and you were once again transported to Hartford Hospital. While in transport to your assigned hospital room, you attempted to kick at other patients in the hospital hallway and knock down the medical equipment attached to them. Once in your room, you used disrespectful language by swearing and using profanity at officers and medical professionals and threatening medical staff to not touch you or render any type of medical aid. Based on your behavior, the staff was once again unable to render any care. You were provided with a urine cup and you proceeded to throw this cup at this parole officer, just missing this officer and hitting another officer in the leg with it. You were provided with a bottle of water, and you once again threw this towards staff, causing them to quickly move out of the way, resulting in it hitting the wall. Your behavior, based on your behavior, you are in violation of breach of peace, Connecticut General Statute 53A-181, disorderly conduct 53A-182, assault of a public safety, emergency medical, public transit, or healthcare professional, section 53A-167C, Exhibit N.
Thank you. And I do just want to make another note regarding the charges that at the time of the prelim, no findings made on alleged behavior during transporting at the hospitals. There's insufficient evidence to support the charge at the time. So I just want to note that that's not taken into consideration at that part. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, CT remained actual custody order, B, CT signed conditions of parole, C, notice of parole violation with offender rights, D, parole violation report, E, PCS misconduct reports, F, CT decision information summary, G, GPS monitoring agreement paperwork, H, pre-sentence investigation report, I, discharge paperwork after visit summary from Hartford Hospital, J, 2 disciplinary reports received to 12/13/24, K, video and pictures, L, staff witness statements, and M is Connecticut General Statute printout. Did you receive notice of parole violation report, and the other documents I marked? Did you review those, sir?
Me?
Yes. Did you review it with your attorney?
You and I had spoke about that earlier this week when I called you. Do you remember that?
Yes, I remember that.
Okay. And counsel has filed the following exhibit that is pre-marked for identification purposes. Defense Exhibit 1, which is a list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No, we don't.
Okay. We don't have witnesses today. So at this time, the state will have an opportunity to present evidence and speak to any evidence submitted at this time. I am going to swear in, Ms. Rosegreen, I know you can't raise your hand. I'm just going to swear you both in, as well as P.O. Davis, in the event that you would like to speak today. So you solemnly swear, sincerely affirm, as the case may be, the evidence you shall give concerning this case should be the truth, the whole truth, and nothing but the truth. So help you God from penalty of perjury.
I do.
P.O. Davis, would you like to say anything at this time?
Yeah, I'd just like to say a couple of things. I just want to emphasize my concern on how much of a risk to the community and himself, Mr. Rosegreen, poses. His behavior has become increasingly dangerous and volatile, in my opinion. I would recommend that Mr. Rosegreen remain incarcerated for up to 1 year. And since I remanded him back on the 12th of December, he's had 3 Class A tickets, 2 on the 13th of December for insulting language and behavior and interfering with safety and security, and also on 12/31/24 for refusing housing. And he's clearly at Garner right now on mental health 5 status. I just don't think he's ready for the community as of right now. I think his needs would be better served incarcerated with the potential to get the treatment he needs and deserves. That's pretty much all I have at the moment. Thank you.
Thank you. Okay, I'm turning over to defense. Would you like to say anything at this time?
Yes, thank you. As to the charges, for charge 1 GPS, I don't have any comments. As to charge 2 curfew, I do just want to note that for the 2 violations on 10/26 and 10/28 respectively, my client was only allegedly 12 minutes late the first time and then 15 minutes late on the second incident. So a very minimal proposed violation. As to the obedience of the law, I would argue the standard has not been met. As to the incident on 12/11, my client was never arrested. No warrants have been served on him for that conduct, despite police being called and being present on scene and observing his conduct. My client has no pending cases. Like I said, no warrants have been served. Additionally, it doesn't appear that law enforcement were ever contacted regarding the incident on 12/12, despite the allegations that were made. I also would just note, on both of these occasions, my client did go to the hospital and they failed to admit him despite his ongoing mental health issues, which, I think all of these things are representative of. I do want to comment as to the tickets that the PO brought up. I will just note, both of those tickets were received while my client was not yet at Garner. He, I believe, was at Robinson and then at MacDougall, but I think this was before they fully had gotten his mental health situation under control, and he now is at a more appropriate facility. And despite his current level, by all reports from him, I believe he has been compliant with any sort of medication and treatment request. So I did just want to note that in response to the tickets, but those are my arguments. And at the appropriate time, I would like to speak to his background and plans for the future. Thank you.
Thank you. Davis, is there anything you want to say before I announce my findings?
Me?
No, not you, the parole officer. I wasn't sure if you want to say anything else before I announce my findings.
No, I think I'm good. It's just the 3 tickets, the 3 Class A tickets that is in a short period of time is pretty serious. You know, it raises his level, and you know, it did get him to another facility. I just wanted the 3 Class A DRs are of significance. Yep, that's all I got.
All right, so I'll be right with you with my findings. So in regards to charge 1, I do find you violated condition GPS based on evidence provided, which is exhibits B, E, and G. On charge 2, I do find you violated that condition curfew based on evidence provided, which is exhibits B, E, and G. And as I previously stated, 3 and 4 and 6 are not taken into consideration as no findings were made at the time of the prelim. So regarding charge 5, I do find you violated the conditional obedience to the law based on evidence that was provided in support of the charge, which is exhibits B, K, L, M, D on part 1 and D, K, M parts 2 and 3. I do find that the behavior does meet the elements of the offense. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, counsel will have the same opportunity. This purpose part of the hearing is to help determine what outcome I will recommend. So, P.O. Davis, would you like to say anything in regards to future plans for the offender or anything else you'd like, any other comments you'd like to make before I make a recommendation? Go ahead.
I've known Mr. Rosegreen for a long time. I just want him to get the treatment and the mental health services that he needs and deserves. That's all I have to say.
Okay, let's turn over to counsel.
Yes, thank you very much. My client, Mr. Rosegreen, is 41 years old, born and raised in Hartford, Connecticut. While growing up, he did transition at one point to some group homes in the state as well. His primary support system is his mother, Miss Mitchell. She resides in Hartford, and his older brother, Lonnie, who lives out of state. My client receives support as well from various people he met through the group homes growing up. He also does have one son who is 21 years old. Upon release of special parole in May of 2024, he was sponsored by his mom in Hartford and remained there until his remand in December. He reports that he had done a patient care associate certification about 11 years ago at Goodwin University, in addition to a lead and asbestos certification about 9 years ago. Prior to his incarceration, he was part-time at Will's Auto Sale LLC in Hartford for about 4 months. He also reports establishing 2 businesses. One was an automobile detailing business called Wipe Me Down Mobile Auto Detail, and then the other was called A&R Salvage and Recycling. He reports that while in the community, he was participating in outpatient groups at Wheeler Clinic in Hartford. Since being remanded to custody, he reports medication compliance and engaging with a social worker while at Garner. Upon reinstatement of his parole, he would like to be sponsored by his mother, Miss Mitchell, again at her residence in Hartford. He is really concerned about his mom. She is elderly, and he's hoping to help her with daily, requirements around the house. He's interested in learning more about construction and home improvement. He hopes to reapply at the Auto Sale LLC in Hartford and also to Cheesecake Factory, where he has a history of working in the past. He also wants to build his businesses up and is open to any treatment recommendations, including going back to Wheeler Clinic for dual diagnosis treatment. I will just note again, this is his first remand. He started in May 2024, has been in since December 12th, so approximately 2.5 months. I think that the recommendation of a year is a little steep for this being his first violation, there being no criminal charges that are pending or anything like that. He did not abscond from parole. He was still going. I believe that a lot of these violations are a result of him undergoing a mental health situation. But currently, he is taking steps to try and resolve that while incarcerated. I would just ask for the soonest date that the hearing examiner is able to give him. I will note that it may make sense for him to have maybe the next board date or the one after, just so that he's able to stabilize before he's released into the community. But I do think that that is more appropriate for Mr. Rosegreen. Thank you.
P.O. Davis, anything you'd like to say before I make a recommendation?
Yeah, I have to add in a couple things.
Go ahead.
The employment, his two self-established businesses, Wipe Me Down Mobile Auto Detailing and A&R Salvage and Recycling, I had no knowledge of. Never heard of either of those, never received a pay stub. As in regards to the part-time at Uncle Will's Auto Sale LLC, the last time I could verify employment there was 10/21/24. He provided me a pay stub for $630 for 40 hours. So that was the last proof that I had that he actually worked there. And the behavioral health treatment at Wheeler Clinic that was supposedly or reportedly facilitated by Joanna. I have no verification from the treatment provider, no emails that he was attending treatment at Wheeler Clinic. I also asked Mr. Rosegreen during reporting sessions to try to get me proof that he was attending those mental health groups and sessions, and I didn't receive that from him. So on my end, I can't confirm that he was ever in mental health treatment because I don't have any proof or verification. And I asked him for that on multiple occasions. As for the education, I can't confirm or deny that, but he never brought that up to me. Everything else looks fine. Thank you.
Thank you. All right, so I'll be right with you with the recommendation. So I do want to put in the record, I see offender was out there for about 7.5 months before he was returned to custody. He is on discretionary parole until August of 2026. There are no prior violations noted. No offender did receive 3 misconducts. He does have 3 years probation to follow after he is done with his sentence. For our records, he has failed 7 out of 10 releases into the community in the past. As well as noted, he did receive 3 Class A disciplinary reports since his return to custody in December. Did note it is very concerning behavior for safety of the community and the offender himself at this time. So taking all that into consideration, as well as no findings that were made in regards to the violation, I am going to recommend that. Second, give you. I will note the offender, the parole officer did recommend a year incarceration. I'm going to recommend that parole be revoked and that he be reparoled for August 12th of 2025. It's about an 8-month period of confinement as a sanction. I do want to note he is done in August of 26, so this gives him a year left on for discretionary parole before going on probation for 3 years. I recommend the following parole conditions: mental health evaluation and treatment as deemed necessary, operation of motor vehicle, no consumption of alcoholic beverages, behavior management program for anger management. I'm going to send this to the parole board for March 13th. So on March 13th, the board's going to make the decision. The board can let the offender out sooner, They can also revoke all discretionary parole or make a date later than the August 12th recommended date. P.O. Davis, there's no problem. Do you want me to put halfway house placement on there as a backup, or is the mother's residence okay?
Yeah, I didn't have a problem with the mother's residence. And
Okay.
I actually spoke with her too. Yeah, I don't have a problem with him going
Good.
back there.
Okay, I just wanted to confirm that. So I'm not gonna put halfway house placement on there. And then hopefully the offender can get stabilized and on a mental health treatment plan prior to being released, to whatever date the board does decide. So you're gonna know on March 13th, Mr. Rosegreen, what day the board wants to release you. So the recommended date is August 12th, but they can let you out sooner. Or they can hold you in longer. It's gonna be up to the parole board, but you're gonna know after March 13th. So you can talk to your attorney and you're gonna get something in writing from us. It's gonna tell you what the board decided and what your conditions are, okay?
If you want to call my office after the 13th, we can tell you what the board decides, okay?
Okay, the only one thing I wanted to discuss was that I'm not receiving my mail on time here. So that's the only thing I wanted to say.
At the facility?
Right.
Okay, yeah, I can, I'm not really sure what we're able to do about that, but definitely let your counselor know, okay? And they might be able to help you.
Good. Get connected with their mental health treatment, sir, so you're better when you go out, okay?
Okay, thank you.
All right, you're all set for today.
Great,
Thank you. Thank you, P.O. Davis.
Thank you. Have a good day, guys.
Have a good day. Morning.
Hold on, I think, I'm just making sure.
I can hear
Okay.
you. Perfect. Thank you. So, Mr. Rosario-Torres, so I spoke to your attorney. He couldn't be here today, so he wants to know, he said that he would go forward the next time. So the next hearing I have is March 11th. So
Whatever you want.
well, it's not up to me. I mean, it's up to you. If you wanna wait for your attorney, because he's got to send us the continuance form, I'm gonna grant it anyways, because I know he can't be here. So do you want to wait for him for March 11th?
Did he say March 11th is good for him?
Well, that's my next hearing date, and I'm gonna send him that date.
Okay.
To make sure he can be there.
Okay.
So do you want to wait till that day?
Yes, ma'am.
Okay, so I'm just gonna go on I figured that's what you'd want to do. So I'm just gonna go on the record and then we'll continue like we did last time till March 11th, okay?
Yes, ma'am.
Okay, so I'm here with Rosario-Torres, Oscar, number 158633, and today is February 28th, 2025. The attorney did notify us he wasn't able to attend the hearing today, and Mr. Rosario-Torres would like to wait for his attorney's appearance, which my next date is March 11th of 2025. So I will accept, that is your request, correct?
Yes, ma'am.
All right, so I'm going to accept your request to continue for attorney representation for my next hearing date of March 11th, okay?
Yes, ma'am.
So you're all set for today, and I'll see you on March 11th, okay?
Thank you. Have a good one.
All right. You too.
Bye-bye. Bye-bye. Yes.
Morning, Ms. Anderson?
Yes.
Morning, we're here for your revocation hearing.
Okay.
So we're gonna get started. Good morning, I'm Neal, a hearing examiner for the Board of Pardons and Paroles. This is a revocation hearing concerning Sanderson Kristin, number 387451. Today is February 28th, 2025. This hearing is being conducted via video at the BOPP Central Office in New York Correctional Institution. This is a public hearing and public access. This hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Kristin Sanderson, 387451.
Thank you. And you have a counsel here today. Please identify yourself.
Yes, Hannah Dean on behalf of Ms. Sanderson. Good morning.
Good morning.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that, more probable than not, the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is placing you back on parole supervision. If I find you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge that the state or PO is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present a relevant testimony. After considering all the evidence presented, I will announce my findings. If I find you violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No.
Okay, you have important rights today. The right to have an attorney present. You have counsel here. You have right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights, and are you ready to go forward?
Yes.
So now review the charge the state your appeal is bringing against you and the information underlying each charge. Charge 1 under release direction residence. You're charging officer court on 10/30/24. You were released from New York CI and placed at Stillman Halfway House in Hartford. At this time, Stillman Halfway House was your only parole-approved residence. On 10/31/24, you left the Stillman House on an approved community pass and failed to return. You made no attempts to contact Halfway House staff or your parole officer. To date, your whereabouts in the community are unknown. On charge 2 is release direction absconder. You're charging officer court on 10/31/24. You were released from New York CI and placed at Stillman Halfway House in Hartford. At this time, Stillman Halfway House was your only approved residence. On 10/31/24, you left Stillman House on an approved community pass and failed to return. You made no attempts to contact Halfway House staff or your parole officer. To date, your whereabouts in the community are unknown. Charge 3 under bail laws, obedience to the law. You're charging officer court on 1/2/25. You're arrested by West Hartford Police. Current charges: larceny 6, possession of drug paraphernalia. Charge 4 are additional conditions, halfway house placement. You're charging officer report at 10/30/24. You're released from New York CI, placed at Stillman Halfway House in Hartford. At this time, Stillman Halfway House was your only approved residence. On 10/31/24, you left Stillman House on approved community pass and failed to return. You made no attempts to contact Halfway House staff or your parole officer. To date, your whereabouts in the community are unknown. Charge 5 under additional condition, mental health eval and treatment deemed necessary. You're charging officer report on 10/30/24. You were released from New York CI, placed at Stillman House in Hartford. During the intake process at Stillman House, you initialed and signed your parole agreement, and you were instructed to complete a mental health evaluation. You failed to complete your mental health evaluation. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, discretionary parole acknowledgement agreement. B, Connecticut Board of Parole remand to custody order. C, notice of parole violation. D, parole violation report. E, notice of parole rights. F, West Hartford Police Report. 1/2/25 arrest. F, Halfway House agreement. Stillman Halfway House. G, Stillman Halfway House incident report. H, decision summary. I is Wheeler Clinic email. Did you receive notice of parole violation report, and those other documents I marked, and did you review those?
Yes.
And counsel has filed the following exhibit that is pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. Do you need to continue this hearing to obtain any additional evidence?
No.
We have no witnesses today. I'm going to put on the record, I received an addendum from PCS. The addendum reported on 11/26/24, the BOPP did issue an absconder warrant for the offender. And on January 8th, 2025, you were convicted of larceny 6, in which you received an unconditional discharge with all the charges nollied. So is now defense's opportunity to like to speak at this time?
Yes, just charge 3, I just wanted to state that is accurate. She received a UCD on the larceny 6 charge. Everything else was nollied. As to the charge 5, mental health treatment, I would just argue for that one that the standard has not been met. Exhibit I does not state that my client failed to do her intake. It's just a response for our information indicating the Wheeler could not complete the request. It didn't have information on record, but it doesn't specifically state that she missed the mental health engagement appointment. So I would just make those arguments, and then I would like an opportunity at the appropriate time to speak to her background. Thank you.
Thank you. All right, so what I'm going to do next is I'm going to announce my findings. To listen to testimony, reviewing evidence. Regarding charge 1, I do find you violated that condition residence based on evidence that was provided, which is exhibits A, D, and G. On charge 2, I do find you violated condition release session absconder based on the BOPP issuing an absconder warrant for the offender and evidence that was provided in support of the charge, which is exhibits A, D, and G. On charge 3, I do find you violated that condition, obey all laws, obedience to the law, based on your conviction of larceny 6 and received an unconditional discharge, as well as exhibits that were provided, which is A, D, and F. On charge 4, I do find you violated condition of halfway house placement based on evidence provided in support of the charge, which is exhibits A, F, and G. And regarding charge 5, mental health evaluation, to make a no finding due to there being insufficient evidence to support the charge, no evidence that the offender had a scheduled evaluation or had missed one. This includes the fact-finding portion of the hearing. Before I make a recommendation, counsel will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to speak at this time.
Yes, thank you very much. So I do know Ms. Sanderson fairly well. I represented her previously in Hartford. Very nice client. I do just want to note that this incident situation here was unfortunate. My client reports that she was attending her methadone intake appointment at Root Center on the specific date in question, and that she unfortunately got on the wrong bus. Once she realized it was too late, she couldn't make up the appointment, and she was concerned because she was beginning to experience withdrawal type symptoms, and unfortunately thereafter panicked. However, as I said before, Ms. Sanderson is a native of the Hartford area. She's 43 years old, born in New Britain, raised in Berlin, resides in Hartford now. Her primary source of support is her mom, as well as various extended family members and friends in the community. When she was released to discretionary, she was at Stillman Halfway House for a few days in Hartford. She has been working to obtain her GED during periods of incarceration, beginning in December 2023. Within the community, Ms. Sanderson gets disability assistance, typically for mental health purposes. She has primary care services established at Community Health Center in New Britain, and she does report that she's currently experiencing pain in both knees and does require surgery, I believe, on both of her knees.
Yes.
Sure. She also reports that upon being remanded to York, she has received methadone through medication-assisted treatment. She's also been participating in the methadone group. She's on the wait list now to start Narcotics Anonymous and also Tier 2 programming. She's in for the GED, and then she's also compliant with any additional medications. Upon reinstatement of parole, discretionary parole supervision, my client's amenable to being placed at a halfway house in Hartford. She wants to finish up that GED program so that she can get her GED and further her education. She eventually wants to enroll in a health information program, health information management program once she's done with the GED, and she's hoping to get her disability assistance reinstated as well. She's open to any recommendations for treatment. She has found the methadone treatment is very helpful. She wants to stay on that in the community and is also looking forward to finding an individual therapist so that she can do individual therapy as well. She's looking forward to addressing her medical needs. And I also thought it was worth noting that per her DIS summary, we did verify she hasn't had a ticket in over 10 years. She just, is quiet. She keeps to herself and does what she needs to do well in the facility. This is her first violation. She was allegedly in the community for a little over 2 months. She now has been incarcerated on her remand for nearly 2 months. I would ask for the soonest board review date. Her sentence expires later in 2025. I believe she could benefit from the assistance of parole to re-enter the community and get connected to services. So I would ask for the board review. Thank
you. So I have listened to all the testimony. I have reviewed all the evidence provided by the state. I will put on the record, you were only in community for a day before you absconded from supervision. You were absconded for approximately 2 months and only returned to custody because you were arrested on new charges that also mirror why you were on parole for. So what's concerning to me is not only are you not staying in the community long enough on supervision that you were granted, is that you're continuing the same behaviors that you exhibited while you were arrested in the first place. So that is concerning to me.
Can I give you an explanation towards that, if possible?
Just wait a moment until she announces her sanction and stuff, and if there's anything additional that you want to say.
But it has something that complies with Mike's detour, what that sanction may be. That's why I'm saying that.
If you do want to speak, I'll let you can speak. I just need to swear you in under oath so that you can speak. So can you please raise your right hand for me? You solemnly swear, solemnly affirm, as the case may be, the evidence you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God upon penalty of perjury?
Yes.
All right, go ahead.
Okay, in terms of the behavior that had taken place, I wasn't, because I have never been on parole before, when I had went for my methadone intake, not aware of them being able to let you go to the emergency room to take methadone because it was a Friday appointment. I had more of a fear or flight reaction to the fact that now that I missed this intake appointment on a Friday, I'm going to go the entire weekend with no methadone, and I was going to therefore have to end up detoxing. And then because of that, it was just the one thing I knew better to do, which was my comfortable reaction towards that, which was, now I'm late for this appointment, so I'm going to just go use now, because now I'm terrified to go back to them and tell them I didn't complete my intake as needed. So that might retrospect send me back to prison. And then also at the same time, the larceny 6 took place because at that point it was maintaining the habit that I now have due to what happened with that intake, which I take full responsibility for. That was my responsibility. I didn't have to go the chain of command, the routes that I went, but in my defense, it was all due to my intake that I was late for the appointment.
So just so you know, for the future, they're there to work with you and put you in treatment. So you missed something, or your parole officer could have directed you what to do next. And the fact that you never came back, and you only came back because you were arrested on new charges. So it's concerning that your response is that, and it wasn't to go through your parole officer or even contact anybody.
I didn't have any of that information. It was at the house that I had left. And again,
you can find a parole office. You can go to any parole office if you have a problem, and they'll connect you. So it's just, I'm voicing this is what I'm seeing, and this is my concerns. I do understand what you said. I didn't know what you said. So based on this information, I am going to recommend that parole be revoked to be reparoled for June 2nd of 2025, which is about a 5-month period of confinement as a sanction. This is allowing 6 months remaining supervision on discretionary parole in the community so that you can connect the services, hopefully, and make better decisions so that you can do better when you're off supervision. I recommend the following parole conditions: halfway house placement, no consumption of alcoholic beverages, mental health evaluation and treatment as deemed necessary, no contact with your co-defendant, James Hyman. My findings are going to the parole board March 13th. So the board's going to review this. So the board can agree with me, they can let you out sooner, or they can make it later. So they can also revoke all your discretionary parole. So it's going to be up to the board that day, and you're going to know what the board's decision is on March 13th. You will get it in writing.
So there's no more hearings after today, correct?
You're done with hearings.
So Kristin, if they decide to increase the sanction, we would get a follow-up hearing. That's somewhat rare though, but if you call our office on the board review date, I believe the 13th you said, if you call our office in the afternoon on the 13th, we can let you know what they decided.
Okay.
So if you're having problems, talk to your parole officer out there or call the halfway house or go back to the halfway house. They're going to want to work with you and try to get you in treatment if you do relapse. So don't be afraid to talk to them. They're not there to put you back. They're there to help you in the community. Okay?
Thank you. Yes.
All right. So you're all set for today. I wish you luck.
Thank you. I appreciate it.
All right. Thank you, Kristin.
Thank you, Hannah.
Good morning, Mr. Williams.
Yes, good morning.
Morning. We're here today for your revocation hearing.
Yes, thank you.
So we're going to get started, all right?
Yes, ma'am.
Good morning. I am P.O. Meissner, hearing examiner for the Board of Paroles and Paroles. This is revocation hearing starting Williams Neal, number 425369. Today is February 28th, 2025. This hearing is being conducted via video at the BOPP Central Office in Carl Robinson Correctional Institution. This is a public hearing and public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Neal Anthony Williams, Jr., 425369.
Thank you. No counsel here today. Please identify yourself for the record.
Yes, Public Defender Robert Famiglietti of the Parole Revocation Unit. Hello, sir.
Hello, good morning.
Good morning.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is, the better weighted evidence must establish that more probable than not the allegation is true. If I do not find there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation will be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure for today. I'm going to read you your rights. Then we're going to review the parole violation charge, the state your appeal is bringing against you. I will review and identify exhibits filed for the record. Counsel will then have an opportunity to present all relevant testimony. After considering all the evidence presented, I will announce my findings. If I find you have violated one or more conditions of your parole, counsel will have an opportunity to speak to your background and history. Do you have any questions about the purpose or procedure?
No, ma'am.
Okay, you have important rights today. The right to have an attorney present. You have counsel here. You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you before the hearing. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
Okay, so we now review the charge, the state your appeal is bringing against you, and the information underlying each charge. I will note that charge 3 has been withdrawn by PCS so that you may participate in the diversion program. That will not be part of this violation. So regarding The violation we are looking at charge 1 under restriction GPS. Charging officer reported you allowed your GPS device battery to shut down on the following dates: 4/27, 5/4, 5/15, 6/24, and 9/8/24. You violated your curfew on the following dates: 6/14, 6/23, 9/12, and 9/28/24. You left the state of Connecticut on 5/16/24 and 8/16/24 without permission from your parole officer. Charge 2 under release direction curfew. Your charging officer reported you violated your curfew on the following dates: 6/14, 6/23, 9/12, and 9/28 as evidenced by GPS monitoring. Charge 4 under travel. Charging officer reported left the state of Connecticut on 5/16/24 and 8/16/24 without permission from your parole officer. Charge 5 under no consumption of alcoholic beverages. Your charging officer reported on 10/1/24 you drove under the influence of alcohol and crashed into a light post, which was knocked over onto the roadway. According to Manchester Police, you admitted to being the driver of the vehicle, which you did not have a valid driver's license to operate. The vehicle was unregistered and uninsured. You admitted to drinking at a bar prior to driving and failed the horizontal gaze field sobriety test. You refused a urine screen. Subsequently, you were arrested and charged with legal operation of motor vehicle under the influence of alcohol and/or drugs, operating a motor vehicle without a license, operating a motor vehicle without proper insufficient insurance, operating an unregistered motor vehicle. And the state has filed the following exhibits that are pre-marked for identification purposes. Exhibit A, signed statement of understanding and agreement, conditions of parole. B, remand of custody order. C, notice of parole violation. D, parole violation report. E, case incident report, Manchester Police Department, ending in 1373. F, GPS monitoring agreement. G, offender misconduct. H, Aetna EM will check monitoring reports. I, state of Connecticut Judicial Branch pending case detail. J, Board of Partisan Parole rep summary. K, Board of Partisan Parole written decision form. L, Board of Partisan Parole decision information summary. Did you receive notice of parole violation report, and those other documents I marked, or did you review those?
Yes, ma'am.
Okay, and council's filed following exhibit that's pre-marked for identification purposes. Defense Exhibit 1, list of parole accomplishments and future plans for parole reinstatement. You need to continue this hearing to obtain any additional evidence.
No, we do not.
We have no witnesses, so I will put on the record, we did receive an addendum from PCS, and the addendum report at 2/6/25. You were granted a diversion program for a legal operation of motor vehicle under influence of drugs and alcohol, and PCS did request to withdraw the warrant for that charge. So now I'm going to turn over to the defense if you'd like to say anything in regards to the charges.
Yes, just briefly. Charge 1, Part C, which I have, it states in the complaint, you left the state of Connecticut on 5/16 and 8/16 without permission from your parole officer. Reviewing exhibits G and H. G being the offender misconduct report. On the first page, the last sentence under misconduct comments, he also left the state of Connecticut on 5/16 without permission. Where did he go? How do I defend? Where's the map? Where's the ping that he was out of state? I looked and further on in Exhibit G, I looked to see if it mentions at all any description as to how, where, when he violated that condition. And it goes on. And it doesn't mention anywhere where he went, how long he went, that he went. He's flown to California as far as we know. How am I supposed to defend that allegation that just merely says he left the state? And then looking at Exhibit H on page, pardon me, I don't know which page it is, but it's a page addressing 5/16. All it says here, it doesn't say anything. It says violation CT, violation home, clear CT, clear home. That doesn't say where he was. I have absolutely no idea where my client was at those periods of time. It doesn't prove that he left the state of Connecticut. Just says violation CT. That in no way, shape, or form can I glean where my client was. That also applies to charge 4. All of those arguments apply to charge 4 as to travel. Thank you. I have no further comments as to the preponderance standard.
Thank you. So I'll be right with you with my findings.
Sorry.
All right, so I'm gonna announce my findings. So regarding charge 1, I do find you violated condition GPS based on evidence provided in support of the charge, which is A, F, G, and H. On charge 2, I find you violated condition curfew based on evidence provided, which is exhibits A, F, G, and H. Regarding charge 4, travel, I do find that you violated that condition based on exhibits A and G. And on charge 5, no consumption of alcohol, I make a finding based on exhibits A and E. So that concludes the fact-finding portion of the hearing. Before I make a recommendation, council will have an opportunity to speak to your background and history. This purpose part of the hearing is to help determine what outcome I will recommend. So if you would like to at this time.
That's just briefly. I'm just arguing, and I'll argue in the future if it's listed like this. It's very hard to defend a client against a travel claim if we have absolutely no idea where they're allegedly went. Mr. Williams is a single 29-year-old male. He received support from his mom, his dad. He has one 8-year-old daughter who he's been unable to see for the past 7 years. This is a significant stressor for him, and he's been a precipitating factor for his substance abuse. Mr. Williams reportedly pays child support, and he hasn't been able to see his daughter for the past 7 years. She is 8 years of age. He graduated middle school before transitioning to Hartford School of Insurance in Hartford. He graduated in 2013. He was a full-time order selector at FHI for 7 months. Then he worked at Transfer Enterprise in South Windsor for nearly 1 year. He was promoted from the chair department to road delivery, in which he assisted the delivery driver. He successfully completed CHR. He completed anger management treatment and med management and groups at Wheeler Clinic. He was in outpatient treatment at CRT. He has been experiencing memory issues since a car accident in October of 2024, where he hit his head really hard. That could be a contributing factor. He has yet to undergo a CAT scan or any screen of his head. After that accident in October, he enrolled in the DUI program. He's scheduled to complete that on March 4th. He also picks up trash outside of the facility as a clearance worker, ground clearance worker every day of the week for the past 4 months. He wished to be sponsored by his father, who I've been in care and contact with. He wishes to enroll in a mechanics program and return to his full-time position at Transfer Enterprises. And he's interested in reestablishing his clinical services at Wheeler Clinic. These are minor violations. He's been held now since October 1st, which is some time. His PO recommended jail until his case is disposed. Well, his case has been disposed, and his PO also recommended substance abuse treatment. My client has done everything that he can to avail himself of substance abuse treatment while incarcerated. I'm asking for that 3/13 date, please. I don't see any other reason to hold him save punitive. I don't believe any of these are violent violations. I believe some of the travel violations may have had to been done as a regard or as a result of him wanting to go to an emergency situation out of state. He did make a request. I guess it was not in time. Thank you for your time and consideration.
Thank you. So I have listened to testimony. I have reviewed all evidence provided by the state. I will note offender was in the community for about 1 year and 4 months before being returned to custody. Did receive 6 misconducts and does have a prior criminal violation in which he served a 4.5-month sanction for. He will be involved in the diversion program once released. Based on all this information, I do recommend that parole be revoked to be re-paroled from March 13th of 2025. It's about a 5.5-month period of confinement as a sanction. This is my soonest date that I have for my board review date to present your case. I recommend the following parole conditions: no consumption of alcoholic beverages, mental health treatment and medication compliance, behavior management program for domestic violence and anger management, a general no contact with Horace Vasquez, a no contact with victims CA and HB, as well as operation of a motor vehicle. My findings are going to go to the parole board on March 13th. If they agree with me, you'll be released that day. Do you have any questions?
Thank you. Thank you for your time.
Just know if you're there past March 13th, that means the board did not agree with me. which means we bring you back and you talk to the board. So just so you know, that is a possibility, but.
So if you're not released on March 13th, give me a call the next day.
Okay.
Okay?
And you don't
Yes,
have time
sir.
to get anything in writing. If you are past it, March 13th, you will get something in writing that'll let you know what happened at the board review. But obviously, if they agree with me, you're gone that day, so.
Okay, so hopefully you get released on the 13th, so you don't need to call me on the 14th. Right?
Thank you so much. Thank you all
You're
for your
welcome,
time.
sir. Have a great day.
You as
You're all
well.
set.
Thank you.
Hi.
Yay.
I'm sorry.
Oh, yeah, I'm so happy you know what's going on.
All right, so I have Harris for you.
Thank you.
You're welcome.
Happy Friday.
Yes, happy Friday. Our computer's in Friday mode already. Harris, you can come on in.
Yo, Schaefer, are you there?
Yep, I'm here.
Perfect. Okay. Good morning, Mr. Harris.
Good morning.
Good morning. We're here today for your rev hearing, okay? We're gonna get started with that. Good morning, I'm P.O. Meisinger, hearing examiner for the Board of Pardons and Paroles revocation hearing concerning Harris Troy, number 3309733. Today's February 28th, 2025. This hearing is being conducted via video at the BOPP Central Office in Osborn Correctional Institution. This is a public hearing and public access to this hearing is available via video live stream. Can you please state your full name and DOC inmate number for the record?
Troy Harris, 309733.
Thank you. We have a parole officer present. Can you please identify yourself for the record?
Christina Schaefer, Parole Officer, Waterbury District Office.
This is a revocation hearing to determine whether you have violated conditions of your release. I will review and make findings of fact as to each of the charges against you. The state, not you, has responsibility to prove the allegations by a preponderance of evidence, that is. The better weighted evidence must establish that more probable than not the allegation is true. If I do not find that there is a preponderance of evidence to support a violation of one or more conditions of your parole, I'll reinstate your parole, which is releasing and place you back on parole supervision. If I find that you have violated one or more conditions of your parole, I will consider whether or not your parole should be revoked. If I recommend revocation, I'll make a recommendation as to appropriate sanction, and my recommendation be given to a panel for a final decision. If the panel wishes to impose a sanction beyond my recommendation, a supplemental hearing would be provided to justify additional confinement. So this is the procedure. I'm going to read you your rights. Then we're going to review the parole violation charge, state your appeal is bringing against you. I will review and identify exhibits filed for the record. The state will then have an opportunity to present a relevant testimony. After the state is finished, you will have the same opportunity. After considering all the evidence presented, I'm going to announce my findings. If I find that you have violated one or more conditions of your parole, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. Do you have any questions about the purpose or procedure?
No.
Okay, your important right. The right to have an attorney present. Do you want to continue without counsel?
Yes.
You have a right to receive the written notice of charges of violation. Did you receive the written notice?
Yes.
You have a right to view the evidence against you. You have a right to submit evidence in support of your case. At this hearing, you have a right to call and examine voluntary witnesses and cross-examine adverse witnesses. Do you understand these rights and are you ready to move forward?
Yes.
All right, so now review the charge the state your PO is bringing against you and the information underlying each charge. So PO Schaefer, if you could please read the charges.
Charge 1 GPS on 6/27/24, you were released to parole supervision. On that day, you were assigned to GPS monitoring. You read, initialed, and signed the GPS agreement indicating you understood those rules. You were then thoroughly instructed by this officer how to properly charge your unit. You have had multiple shutdowns of your GPS unit due to failure to properly and fully charge your unit. You had shutdowns on July 7/24, July 16/24, September 27/24, October 7/24. This is a violation of your GPS agreement. Charge 2, program participation. On June 27/24, you were instructed to participate in the Explore group as stipulated by your parole conditions. On October 14/24, you were discharged from Explore due to violating attendance rules. Due to your discharge, you were no longer able to participate in the program. Charge 3, obedience to the law. On 11/4/24, you had an argument with your girlfriend. Witnesses overheard you state that you would beat her ass. The police were contacted and an investigation was conducted. The victim stated to police that you made this threat. Based on your behavior, you were subsequently arrested for threatening in the second 53A-62A1. Charge 4, behavior management program. On 6/27/24, you were instructed to participate in the behavior management program Explore as stipulated by your parole conditions. On October 14/24, you were discharged from Explore due to violating attendance rules. Due to your discharge, you were no longer able to participate in the program.
Thank you. And the state has filed the following exhibits that are pre-marked for identification purposes as Exhibit A, remand to custody order; B, parole condition; C, parole violation report; D, notice of parole violation; E, Waterbury Police Department case incident report ending in 4979; F, 3, misconducts dated 7/16, 10/15, 10/15/24; G, CSSD Explorer discharge report; H, GPS monitoring agreement; I, GPS violation report; J, State of Connecticut BOPP decision information summary; and K, it's State of Connecticut BOPP revocation hearing summary 3 dated 5/10/22, 5/26/23, and 7/11/23. Did you receive notice of parole violation report, and those other documents I marked? And did you review them, sir?
Yes.
Okay. Do you need to continue this hearing to obtain any additional evidence?
No.
Okay. We have no witnesses today. So at this time, I'm going to swear in you, Mr. Harris, as well as P.O. Schaefer, in the event that you would like to speak today. So can you please raise your right hand? You solemnly swear, sincerely affirm, as the case may be, that the evidence you shall give in this case should be the truth, the whole truth, and nothing but the truth, so help you God, from penalty of perjury?
Yes.
Yes.
All right. So at this time, the state is going to have an opportunity. If you'd like to speak to any of the evidence at this time, you may at this time.
Mr. Harris has had great difficulty being in compliance with his GPS conditions, as shown in the parole violation report and the misconducts he received. Additionally, with the misconducts, he's received numerous just verbal counseling sessions on how to keep his unit charged and what the agreement is for the GPS. As far as the Explore discharges, he has a significant history of failures in that program. 7 unsuccessful charges from the Explore program while he's been on parole, and 1 while he was under my supervision. His pattern of domestic violence continues in the community, as evidenced with this most recent arrest. That's all.
Thank you. So at this time, you can respond to the charges if you'd like. However, remember that you may remain silent if you so choose. Would you like to say anything at this time, Mr. Harris?
No. Thank you.
Okay. I'll give you another chance at the end, but so what I'm going to do next, I'm going to announce my findings regarding the charges. So regarding charge 1, I do find that you violated condition GPS based on the evidence that was provided, which is exhibits B, F, H, and I. On charge 2, I find you violated condition program participation based on the evidence that was provided in support of the charge, which is exhibits B and G. On charge 3, I find you violated condition obedience to the law based on your conviction of threatening second physical threat and received a sentence of unconditional discharge. And on charge 4, I find you violated the condition behavior management program based on evidence provided, which is exhibits B and G. I will note I did receive that addendum from PCS, which reported on January 14, 2025. You were convicted of threatening second physical threat and did receive an unconditional discharge for that. So that includes the fact-finding portion of the hearing. Before I make a recommendation, the state will have an opportunity to speak to your background and history. After the state is finished, you will have the same opportunity. The purpose part of this hearing is to help determine what outcome I will recommend. So, P.O. Schaefer, would you like to say anything at this time?
Mr. Harris was released from a previous violation on June 27th of 24 to parole and was with my supervision until this arrest on November 4th of 2024. During this period of supervision with me, as mentioned earlier, he did have 3 misconducts for his GPS violations and many verbal counselings. Prior to this violation, he did have 3 previous criminal violations while on supervision for this parole term. His pattern of criminal behavior accompanied with significant non-compliance to his parole conditions, previous substance use, warrants his parole to be revoked. His end of sentence is May 7th of 2025. If he is going to be reinstated, I would recommend a halfway house.
Thank you. All right, Mr. Harris, would you like to make any statements regarding future plans going out or anything like that at this time?
I basically recommend the same thing everywhere else, so I can basically like graduate myself back to society. I got a few goals, I got a few jobs lined up, and I would like to go in a different town so I could stay on the right path, and I just want to do the right thing. I sat back and thought about everything I was going through, and I'm just ready for what's next. That's it.
What area would you go to?
New Haven. I have Yale have a program for felons, and somebody gave me a lead, and I'm just trying to follow that lead and go from there.
Right. So I have reviewed all the evidence. I've listened to testimony. I will put on the record, offender was in community for about 4 months after his last reinstatement before he was arrested on these new charges and received a new conviction for a domestic violence related offense on January 14th of 25. Offender does have 3 prior criminal violations on this period of, this is discretionary parole supervision, and has received 3 misconducts within that 4-month period. The officer is recommending a full revoke. I do see, per our records, the offender has failed 10 out of 10 past community releases into the community. And he does have 5 years of probation to follow. Based on all the information today, I am going to recommend that parole be revoked, that you remain incarcerated until your EOS date of May 7th. This is about a 6-month sanction. You do have 5 years probation to follow. I will present this to the parole board on March 13th. So the board's going to make the final decision on March 13th. This is just a recommendation, so they can let you out earlier if they do want to. They can let you out as soon as March 13th. It will be up to the board. Do you have any questions, sir?
No, man.
No, so you do have, like I said, if they don't send you back out, you do have probation to follow, so you can work with them to help you get a lot of the things that you're going to need out there to help you out.
Right.
Okay, I wish you the best of luck, sir.
Thank you.
You're all set.
Right, thank you.
Thank you.
Thank you, P.O. Schaefer.